Mr. McBroom to get us started.
Good afternoon. The Metropolitan Short-Term Rental Board of Appeals is now in session for the regularly scheduled meeting of March 25th, 2026. I'm Short-Term Rental Property Chief Bonnalynn Dr, and I'll be presenting the cases to the board for review in today's public hearing. At this time, I would ask everyone to either turn off their cell phones or put them on silent as not to disrupt today's meeting. The procedure will be for staff to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to the case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for rebuttal. The board and their rules provide for cases without opposition 5 minutes total for the appellant, including members of the public speaking in support of the appeal, to present their case and supporting comments. For cases that have opposition, the rules provide the appellant, including members of the public speaking in support of the appeal, 10 minutes total for their presentation and rebuttal of the opposition's presentation. The appellant must reserve a portion of the allotted 10 minutes for their rebuttal. For members of the public speaking in opposition, 10 minutes is provided. This is 10 minutes total for all speakers combined and not 10 minutes for each speaker. For members of the public that want to submit comments to be entered into the record prior to the meeting that are either in support of or opposition to an appeal, the comments must be submitted to the board staff no later than 5 days prior to the public hearing. Those comments can be sent to strboard@nashville.gov. Documentation supporters or opponents wish to provide to the board after the deadline can be presented to the board members by providing 8 copies at the public hearing. However, the board may elect to defer cases in order to review any materials received after the deadline. The Metro Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of show cause hearing. The board will go through the cases set for the public hearing today. After both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the power to act in these cases before us today under the provisions as outlined in section 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7-member board be present to constitute a quorum. The board rules require a majority vote in the affirmative of members present to grant the appellant's application. In the event that a majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled public hearing. Applications that that fail to receive a majority affirmative vote at the next regularly scheduled public hearing shall be deemed denied by operations of law. Any aggrieved party may, within 60 days of the entry of an order stating a board decision resulting from an appeal hearing, appeal the finding of the board under common law of certiorari in accordance with TCA 27-9-101 and following to the Chancery Court within the same 60-day period. After that time has elapsed, the board decision becomes final. No further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you have applied. It should be noted that the permit must be obtained within 2 years for the board approval to remain valid. I submit that all cases have been filed in proper order. All appellants have been notified as required by the code. All affected property owners have been notified, and the legal notification sign requirements have been met as required by the code. Chairman Caputo, at this time, before we move to the cases to be heard, see if we have any elected officials that wish to speak. Seeing none, we will be ready now to move to the first case, which is 2025-028. Is the appellant present? Is there any opposition? Seeing none.
Mr. Helms, why don't you come on up and you can grab a seat right there, but we're going to start with Metro and then we'll get to you.
Yeah, you're correct. You're correct. I apologize. This is 2026-004. The The permit was revoked as the property is deemed not to be the principal or primary residence of the owner or appellant. This is an RS 7.5 zone district which allows only owner-occupied permits. This is governed by BL 2020-187 as the permit was issued December the 9th of 2016. The board has discretion under BL 2023-136. On June the 4th, 2016, the appellants Alyssa Mara Manchella and Justin Bradley Helms were married in Salem, Massachusetts. On August 22nd of 2016, the appellants acquired the property at 1009 Iverson Avenue, Nashville, Tennessee, 37216. On September 9th of 2016, an owner-occupied permit application was submitted. December the 9th of 2016, the permit was issued. May the 8th of 2020, our office received a complaint that was submitted on the Hub Nashville. It read that the owners, Alyssa and Justin, have an owner-occupied permit. They've moved to Boston. At that point, we were unable to substantiate the complaint with legal documents. In May of 2025, our office received a complaint called in by phone claiming that the owners no longer occupied the property and haven't occupied it for some time. Inspector John Fells opened an investigation. The owner-occupied STRP permit lists the person responsible for billing as Justin Helms with the address of 1 Canal Street, Boston, Massachusetts, 02114. Metropolitan Assessor of Property lists the owner of 1009 Iverson Avenue as Alyssa Mara Manchella and Justin Helms with the address, or the owner's address as 391 High Street, Medford, Massachusetts, 02155. The Metropolitan Trustee lists the owner of 1009 Iverson Avenue as Alyssa Mara Manchella and Justin Helms with the owner's address as 391 High Street, Medford, Massachusetts. The annual tax records recorded on Metropolitan Trustee's website going back to 2023 lists the owner of 1009 Iverson Avenue as Alyssa Mara Manchella and Justin Helms with the owner's address as 391 High Street, Medford, Massachusetts. Prior to that year, the annual tax records recorded the owner's address as 1009 Iverson Ave. Medford, Massachusetts is a suburb of Boston, Massachusetts, as the map on the following page of your summary illustrates. 391 High Street, Medford, Massachusetts is approximately 20-minute drive from 1 Canal Street, Boston, Massachusetts. A browser search yields Justin and Alyssa Helms' current address is 391 High Street, Medford, Massachusetts, 02155. Rocket Reach profile page for Alyssa Helms lists her as CEO of Helms B&B based in Boston, Massachusetts. The Visipedia profile for the Helms B&B LLC's initial filing was January 11th, 2022. The registered agent for the LLC is Alyssa Helms, 1 Canal Street, Boston, Massachusetts. The LLC's principal address is 1 Canal Street, Boston, Massachusetts. A business entity search with the Secretary of the Commonwealth of Massachusetts finds Helms B&B listed as a domestic LLC that was organized on January the 11th of 2022. The location or address where the records are maintained as 391 High Street, Medford, Massachusetts. The resident agent is Alyssa Helms at the address of 1 Canal Street, Boston, Massachusetts. Alyssa Manchella Helms' LinkedIn page lists her location is Boston, Massachusetts, and it lists her as founder and CEO of Helms B&B, January 2019 to the present. The page also contains a post written by Ms. Helms about acquisition of Vermont properties that are part of the company's portfolio, which this narrative states 7 Green Mountain state listings owned or managed by the company. Another post on this page written in the fall of 2025 states how every foliage season we move back in and remember how far we've come. This is a reference to the Woodbridge Inn located at 5763 West Woodstock, Vermont. The entire post is included in the summary. Secretary of the Commonwealth of Massachusetts also lists Helms B&B Management Incorporated as a domestic profit corporation organized July the 24th, 2023 at address 1 Canal Street, Boston. Registered agent is Alyssa Manchella Helms at 1 Canal Street, Boston, and the president is Alyssa Manchella Helms. 1 Canal Street, Boston, Massachusetts is a mixed-use tower with apartments, offices, and restaurants in downtown Boston, and it's pictured in the summary. Helms B&B LinkedIn page lists the company's location as Boston, Massachusetts, and Helms B&B Facebook page has a photo dated November 10th, 2025 at 4:34 p.m. Boston, Massachusetts, with the caption, Helms B&B is at Boston Logan International Airport. Alyssa Michela Helms' Facebook page lists her as the owner at Woodbridge Inn and Bed and Breakfast and is the founder of Helms B&B. The Helms Instagram page lists her as the innkeeper at Woodstock, Vermont, living in Boston, Massachusetts. Ms. Helms has a vehicle registered at 391 High Street, Medford, Massachusetts, and Ms. Helms is a licensed certified public accountant in Boston, Massachusetts, licensed by the Massachusetts Board of Public Accountancy. The Woodbridge Inn website and inscription introduces you to the owners and goes on to read, when renting by the room, we or our trusted innkeepers will be at the home to welcome you and to serve your full breakfast. According to the Woodstock Township records, the Woodbridge Inn property located at 5763 West Woodstock Road, Woodstock, Vermont. The owners are listed as Justin and Alyssa Michela Helms, and with the address of 391 High Street, Medford, Massachusetts. The property is also listed as having a homestead. The Vermont homestead laws, as referenced in the official Vermont government website, states that to qualify for a homestead, you must be a resident of Vermont or you own and occupy a homestead as your domicile. Vermont Title 32 Taxation and Finance defines residency as follows. Chapter 151 Income Taxes, Subchapter 001 Definitions, General Provisions, Ordinance 5811 Definitions, Residency, and individual qualifies for residency in the state for that portion of the taxable year of which the individual is domiciled in this state or the individual maintains a permanent place of abode within this state if the individual both maintains a permanent place of abode and is present in the state for more than an aggregate of 183 days of the taxable year. State of Vermont Agency of Administration, Department of Taxes webpage reads as follows: homestead property and commercial use. As long as the property meets the requirements of Vermont homestead, and part of the homestead property may be used for commercial purposes, such as rental. For more than 25% of the dwelling used for business purposes, then the portion must be reported as a non-homestead on the homestead declaration. However, if any part of the dwelling is a rental, then the percentage that is a rental must be reported. Outbuildings used for business or rental are considered non-homestead. Business use: if there is no business use or the business use is 25% or less, then enter 0.0. If more than 25% business use, enter the percentage. Generally, the business use is same as reported on the federal income tax. There's also a non-homestead portion on the property for the purposes of taxation due to the property being rented. At a fast people search of Alyssa and Justin Helms finds them both listed with current address at 391 High Street, Medford, Massachusetts. Justin Helms' LinkedIn page lists him as employed at Grubhub in Boston, Massachusetts as Director of Technical Brand Management for 5 years and 6 months, March 2019, August 2024. The Airbnb ad for the property lists the rental as the entire home. The VRBO ad for the 4 bedrooms or in other words, the entire home. Based on the floor plan contained in the permit application submitted on September 2016, the property contained and was permitted for 3 bedrooms. In 2020, the 4th bedroom was added and the permit was updated to reflect this. On March 20 of 2019 to October of 2025, the property has 173 documented stays based on reviews on the website advertisements. We can also speculate that there have been more stays than this, as not everyone leaves a review on their stay. Given this volume of rentals of the entire home, coupled with the fact that Mr. Helms was employed in Boston for most of this time, and Ms. Helms is the CEO of Helms B&B located in Boston from January 2019 to the present, it's difficult to see how the it could be the owner's primary residence. BL 2019-79, effective date 11/18/2020, prohibits advertising whole entire home for the owner occupied STRP. Mr. Helms has a vehicle registered at 391 High Street, Medford, Massachusetts. The revocation letter dated 7/14/2025 was mailed to 1009 Iris in Nashville, Tennessee, and 391 High Street, Medford, Massachusetts, informing the permit holders that the permit would be revoked effective July 29th, 2025. July 30th of 2025, Inspector Phelps reviewed the ads for the property and found they remain active. He made a site visit to the property and posted a revocation letter and a stop work order documented with photos. September 29th, 2025, the appeal was filed. On October 2025, the VRBO ad for the property has documented 3-night stay that is verified review by VRBO. In December of 2025, the VRBO had for the property has a documented 2-night stay that has been verified review by VRBO. It is our belief that the claim that the Helms primary residence is 1009 Iverson Avenue is merely an attempt to continue the operation of their not owner-occupied STRP with an owner-occupied STRP permit. There are not owner-occupied permits available in numerous zone districts in Metro Nashville. However, having not owner-occupied STRPs in residential zone districts is not the Metro Council's intent, as evidenced by the STRP ordinances. BL 2017-608, effective February the 2nd, 2018, that section for the land use tables excluded not owner-occupied STRP permits from all residential zone districts except residential multifamily. BL 2019-1633, effective September 29th of 2019, that again adjusted the district land use tables and excluding not owner-occupied STRP permits from all residential zone districts. The complaints that have been registered for the property are the hub in June of 2017, advertising excess bedrooms, excess occupancy, and the ads were not corrected, resulting in a warrant being issued to appear in environmental court. November of 2018, excessive noise, advertising excess bedrooms, advertising excess occupancy. On June of 2019, advertising excess bedrooms. May of 2020, property is not owner-occupied. And the STRP hotline had June of 2018 excess noise.
Okay, great. Any questions for Metro before we hear from the appellant? No? Okay. So, Mr. Helms, there's a button on that microphone. So when you're ready to talk, you're going to press that button to open the mic and start with your name and your address and tell us about your situation. And there's no one here in opposition, so you have 5 minutes, but don't feel like you have to use the whole thing.
Justin Helms, 1009 Iverson Ave, Nashville, Tennessee, 37216. As y'all noted throughout that extensive thing, my wife and I run a property management company. We have 42 properties. We're opening 4 more, and so we travel nonstop. Our business is based in Massachusetts for a couple of reasons. One is that Massachusetts has ACA benefits, and so we're able to pay our people health insurance, which we cannot do in Tennessee. That is why we have a rental property there. That is why we have the cars registered there, because the business pays for those as well. I don't know.
You don't have to hold the button.
Oh, sorry.
It should stay on. Okay, great.
When we got the letter, we were in Italy, so that is why there was the 15-day we didn't respond. We weren't here because, again, we travel a ton. We are, as you noted, in Vermont for 2.5 months out of the year. I don't know anything about the homestead and the residency requirements of Vermont, but we are kind of nomads. But the documents that I understood that we needed to have are driver's license, mine is at Iverson. Voter registration, mine is at Iverson. I believe it was a W-2, mine's at Iverson. And I sent all these documents, and then the homeowner's policy through State Farm. So I guess I've asked the people who, I guess, I don't know if you call them the board, the investigators, whatever. And there was my apologies, if you could scroll back, there was a thing saying like that we ignored something, but we filed the appeal on September 29th because I was in communication with, I believe his name is Joey, and David, and Alyssa, to just kind of understand, like, what are we in violation of after almost a decade? And there was no like real statute. I was like, do we need to be here a certain number of days? Because we can adjust to anything based on what the requirements would be. But that has never been made super clear. And so that's where we stand. We're all over the place. Like we have 2 places in Vermont, which I'm sure y'all know, 2 places in Vermont, 2 places here, a place in South Carolina, and then we manage 35 other properties for people that we are traveling to in 8 different states. So yeah, we're not going to be here probably 181 or 182 or 183 days, whatever that requirement would be, unless you state that is what we need to do, and then we'll do it. And once our kids get older and in school, we'll have to lock down somewhere. But right now, our house here is our primary residence, both what we consider it and what our IDs consider it, and also what our mortgage consider it, because our other 3 houses are commercial loans, and our Massachusetts address is a rental, both Canal Street and High Street.
Okay. May I ask, since you brought them up, how old your children are?
One is 4, one is 5 months.
And the 4-year-old, is the 4-year-old in a pre-K?
He is.
And where is he at pre-K?
He's in Massachusetts, but it's 90 days. So,
Somewhere.
like, for example, when we were in Vermont, we have to have somebody take care of, we have to have somebody help. We have an au pair that takes him to school, and then we try to divide our time. Somebody has to be at the end the entire time.
I'm sorry, I kind of asked a question before I determined that you were done with your presentation, right?
Yeah.
Okay, and you can leave that open, that's fine. Anyone else have questions for the appellant before we, yes, please, go right ahead. Huh, oh wait, maybe.
This one works. That one doesn't? Oh, I was hitting the wrong button. I'm sorry. Sorry, apologies. You said you don't know anything about the homestead exemption in Vermont. You don't have any idea why you have an exemption for that property that says you live there, that is your domicile?
I don't. We have a hotel permit for the bed and breakfast, which is rare for the bed and breakfasts, at least in Woodstock. The others, they are run as bed and breakfasts, which is under a different title. The previous owners had a hotel license. We worked with the state to continue that hotel license. So I don't know if that's what the exemption is, or if I know we're not there 183 days, I wouldn't think, but, so I'm not sure what they're.
Got it.
But since we work through the state, I'm guessing that they have the
It's
reasons
just
for
a
the
little,
exemption.
when we look at these cases, we take all of the documentation into account. When you have an official exemption saying, this is our domicile, this is our primary residence in another state, like that carries a lot of weight. So I would recommend looking into that, particularly if you know that you're not meeting the requirements, because that's problematic for me personally, and I would imagine for some other board members. That's my only question.
You mentioned that Massachusetts has ACA plans that you wanted to take advantage of. So were those purchased through the Mass Health Connector?
They were, yes. I believe we are on, Alyssa would know better than me. I believe we are on something else now. They are, because there's Mass Health Connect, and that is for low-income people, I believe. Don't quote me on that. I don't want to get arrested for not knowing that. And then there's the ACA where you can pick from a variety of plans, and then there's a low-income one. I'm not sure which is which.
I'm pretty sure that regardless of which one you choose, coming through the Commonwealth of Massachusetts, you would need to be a resident of the Commonwealth of Massachusetts in order to take advantage.
One would assume, but the people on our team are, there's one that's on Cape Cod, and the other one is in Lynn, maybe?
Okay, so you've got someone on the North Shore, Metro North, and you got someone down the Cape, but for you to take advantage of it, you're not.
I have a full-time job. We run our insurance through us.
Okay,
or through my
So
work.
it's just for the ACA opportunities for your employees? Okay,
We have an accountant who's also based in Massachusetts, and that was her recommendation, was headquarter it here because you can take advantage of things that the other states in which you have properties you can't do.
okay.
Well, I guess we don't have property in Mass. We rent in order to have the location.
And do you have a car registered here as well as a car registered in Medford?
No.
And how
No
do you get
car
around here? Since this
When
is your
we're here,
full-time.
we'll either rent or we'll Uber or we zip car. Yeah.
You do that with your 5-month-old and your 4-year-old?
No, we rent with them. We have the car seats at the house. We have car seats at all our houses, at our personal houses.
Anyone else have questions?
Maybe just a clarifying one. So you're full-time employed with Grubhub still?
No,
Okay.
it's a company called Infuse Hospitality. They're out of Chicago, and also Grubhub is out of Chicago. I know my LinkedIn lists Boston because from March 2019 until February 2020, it's a subsidiary that was based there, but I've been remote.
Okay, and then,
I was remote before, but March of 2020, beyond every employee was remote.
okay, thanks for that. And then you mentioned that you and your wife were traveling when the first communication came in. But we're documenting 5 additional stays since that was sent. Can you,
5 short-term stays?
VRBO cites 3 stays in October and 2 in December? Oh,
5
I misread
nights.
that. So 2 stays. But yeah, so the property was still advertised after you received the letter?
I doubt it was advertised. I bet those were booked before. I don't quote me on that, but I know that because y'all can see it, so we took it down immediately. Or we didn't take it down. They're both still up, but they're 30+ day stays because we've had like visiting Vandy professors and stuff in the past that have stayed.
Cool, thank you.
Mike, any questions? Nicole, any more? Tom? No? Okay. Thank you so much for all the information, Mr. Helms. We're going to close the public hearing. We're going to discuss this amongst ourselves. Unless we need more information from you, at which time we would reopen the public hearing, we're not going to have another opportunity to communicate. So even if you hear things you object to, I'm sorry to say, there is not another opportunity for you to weigh in. Okay?
Okay, but I need to stay.
Well, if you'd like to stay and hear the outcome,
Okay.
great.
But it would
And
be
if you
like
don't
right
want to
now.
hear the
You made sorry, it sounded like y'all were gonna like hear everything and then go off into a room. And,
Let's
okay.
take this in camera. No,
Yeah.
no, it's all very transparent. You will hear everything we have to say. I'm just letting you know that this is our last opportunity to communicate, okay? So you can stay there, you can take your seat, whatever you like. Thank you so much. All right. Well, first, as an aside, I will tell you that Woodstock, Vermont, if you haven't been there, is one of the most beautiful places on planet Earth. So they're very lucky people. I appreciate the nomad lifestyle. I get it, but I don't see anything in what Mr. Helms has told us that overcomes massive information that indicates that the zoning administrator did not err in their decision. That's where I'm starting.
I would also just sort of point back to what I said when I was speaking to the appellant, that for me, the Vermont homestead exemption is dispositive. You simply cannot have a legal document that says, I live in another state, and then tell us that you live here. That just, no matter what other documentation there is, I understand if maybe that was an oversight or whatever it was. We don't really have the full story there, but what we do have in black and white is that the state of Vermont considers the Helmses to be domiciled in Vermont, and they're receiving tax benefits. That is what a homestead exemption is. And so that's dispositive for me personally.
I agree on the homestead point. I think that as we've seen, you can have one or the other, not both. And I think in this case, I think that the homestead exemption is a little bit bigger of a deal than our owner occupancy requirement.
Yeah.
And so I think that is what, that's the standard that I'm going to be going by.
Yeah, and I'll just add on to what everyone's already said. Homestead Act was the first thing I wrote down, reading through the case file. Yeah, I just can't overcome that one. The other things, can be explained away. I wish I had a nomad lifestyle. But the homestead exemption part is what got me.
Yeah, and as y'all know, I'm like exceedingly willing to take people's word for things.
You said exceedingly, not us.
Well, and it's true, and I do think that you can explain some things, like, so many people are working remotely now. I understand business reasons to base your business in different states, like, that doesn't concern me, it's the homestead exemption. Can I make a motion? Of
course.
Okay, well, I will move that the zoning administrator did not err, and that we will not grant relief to this appellant.
Seconded. Can I see a show of hands? Great, thank you so much. So, Mr. Helms, you heard the results there. If you would like to communicate with Mr. Hargis and/or Alicia and talk to them about your concerns about what does dictate someone's permanent residence, I think that would be a great conversation to have. Thank you so much. Appreciate your time. Safe travels. Okay. Next case. Oh,
Our
and
next
Mr.
case-
McBroom, I'm so sorry to interrupt. When we get to the case about which we heard from the council member this morning via email, would you be so kind as to point that one out to us?
This is that case.
This is it, okay. We don't, but we'll brief you. Or actually, Tom, are you briefed on this matter?
A little bit.
Okay.
I was in the email that she sent.
Okay, why don't we wait until after Metro and then Tom can fill us in? Is that appropriate? Is that appropriate? Okay, great. Thank you. Sorry, Mr. McBroom, it's all yours.
Yes. This is case 2026-005, 446B Humphreys Street. The STRP was revoked due to repeated violation for advertising excess occupancy. This is an MUL zone district, and both owner-occupied and non-owner-occupied permits are available here. This is governed by BL 2017-608. The effective date of that bill was February the 2nd of 2018. And this is quoting from that bill, 1704-060.1. Short-term rental property, STRP, not owner-occupied, means a residential dwelling unit that is not owner-occupied, containing not more than 4 sleeping rooms and is used and/or advertised through an online marketplace for rent for transient occupancy by guests. 17.16.070.U.F regulations, maximum occupancy. The maximum number of occupants permitted on an STRP property at any one time shall not exceed more than twice the number of sleeping rooms plus 4. Advertising an STRP for more occupants than allowed by this regulation shall be grounds for revocation of the permit. Every iteration of the STRP ordinance since BL 2015-94, effective date January 25th of 2016, has contained the wording, advertising an STRP for more occupants than allowed by this regulation shall be grounds for revocation of the permit. This property's permit was for 4 sleeping rooms, twice the number of sleeping rooms plus 4, totals 10 occupants maximum. 17.16.070.U.4.L, denial or revocation of permit. Roman numeral 3, before revoking any permit, the Department of Codes Administration shall give permit holder 15 days written notice of the alleged violation against him or her. Any denial or revocation of an STRP permit may be appealed to the Short-Term Rental Appeals Board as an administrative appeal pursuant to Section 6.28.035.b of the Metropolitan Code. Once an STRP permit has been revoked, no new permit shall be issued to the applicant for the same property for a period of 1 year from the date of revocation. The board has discretion under BL 2023-136. On November 14th of 2018, Mr. Krabousanos acquired the property at 446B Humphreys Street, Nashville, Tennessee, 37203. January 17th of 2019, a multifamily, not owner-occupied STRP permit application was submitted. January the 30th of 2019, the permit was issued for 3 bedrooms, 10 occupants, based on the floor plan submitted with the application. Inspector John Phelps received, August 29th of 2024, Inspector John Phelps received an email complaint from numerous properties advertising excess occupancy, and he began to investigate these properties. On November 21st of 2024, Inspector Phelps investigated the property at 446B Humphrey Street and found that the website ad was advertising excess occupancy. A notice of violation was sent. The advertisements were corrected within the remedial time period, and the case was closed. Pardon me, I appear to be missing a page from my summary. Just one moment. On December 17th of 2025, Inspector Phelps revisited the property's ad and found that they again, November. Yes, December 17th of 2025, Inspector Phelps revisited this property's ad and found that they had again were advertising excess occupancy along with numerous other properties managed by this property management company, which had previously been cited for this violation. Inspector Phelps and I presented these findings to the zoning administrator. He determined that as repeat offenders, the permits were to be revoked. There were 20 revocations in all. Soon after we sent the first 4 revocation letters. On January the 6th of 2026, a revocation letter was sent for this property. In early January, our office was contacted by the owner's representative on this appeal, Mr. Rahib Dawan. Mr. Dawan is the owner of a property management company that manages all these properties, and he requested to meet with the zoning administrator, Hargis. On January 13th of 2026, Mr. Dawan met with zoning administrator, Joy Hargis, and he informed him that he had purchased a property management company on April the 30th of 2025 and did not own it when they were cited previously for excess occupancy. The previous owners were Emily Stewart and John White. Inspector Phelps wanted to know if John White was still involved with the company. In a follow-up email to the meeting, Mr. Hargis asked for Mr. White's current involvement, and Mr. Dawan answered that he had no involvement. And as of this writing, March 11th of 2026, the ads continue to list the host as Visit Nashville Now, John. Mr. Hargis informed Mr. Dawan that he needed to appeal one of these revocations and that whatever the board's decision was on the case, he would apply it over the other 19 as well. The Metropolitan Code holds the property owner responsible for the violations at their property. They may choose to delegate this responsibility to a property manager acting as the owner's agent, yet the owner ultimately bears the responsibility. This is the second time the ads for this property were found to have been advertising excess occupancy. The final few pages in your summary are screenshots of VRBO advertisements cached by Granicus Host Compliance from September and October of 2025, in which the occupancy of 14 guests is advertised. There were 2 emails in opposition to granting the appeal, one on March 3rd and one on March 6th of 2026.
Okay. Any questions from Metro before we hear from Tom? Please, go ahead.
So I understand what the Metro ordinance says about violations of advertising excess occupancy. I also know that there is a state law about when you can revoke a short-term rental permit. And I was wondering what the interplay of that state law is with Metro's ordinance, because I thought it was something like there had to be 3 violations of generally applicable law.
Well, this, no, actually, the generally applicable law was, is a different section of the ordinance and of the state law.
Okay.
This, the state law states that the ordinance in effect at the time the permit issued is a governing ordinance as long as the permit is maintained.
Got it.
And this, this one was issued some time back, so it was governed by 2017-608, which was it was a stiffer ordinance.
Yeah, yeah. Okay, I just wanted to make sure that, because I know that gets brought up.
And can I ask a clarifying question, that we're talking about 20 properties in total, and that our decision will impact the other 19? Who are the owners of those? Are they all managed by this management company, or are they, and they're all different owners, or are there groups? Do we know?
I don't have the breakdown. I think that they're mostly individual
Okay.
owners. There may be an owner that has more than one unit, but it's not like it's someone that has majority of the units. But it just happens to be that they're managed by this property management company.
By this property management company, okay. Is Mr. Duan here? Yeah, please come up. Please, go ahead. Just have a seat, we're gonna get to you in just a second. We have a few things to manage first.
I wanted to ask, personally, I'm a little uncomfortable with making a decision for one property that affects other properties that aren't owned by the same people. I understand they're managed by the same property management company. And so I want to make sure we're on good legal footing, Hannah, to do that, because that makes me uncomfortable.
Let me review again what the zoning administrator said.
Well,
I may need to chat with you.
This is something that he's applying administratively. This does not affect their right to appeal. If any of these individual owners are not happy with your decision, they still have the right to appeal individually. We were just trying to avoid flooding the board with 20 cases.
Okay, but so what you're saying is that technically our decision is not, on this case, does not apply to the other cases, but Mr. Hargis will use that instructively as to how he should approach the other cases administratively?
He will apply it administratively, yes.
Okay, and.
But they still have the right to appeal.
Got it, okay. And then if we deny this appeal, what's the waiting period for reapplication?
Any revocation carries a 1-year waiting period.
Okay, great, thank you very much.
Okay, so that's good. So Joey's going to use this only to inform his moving forward. But we did have some communication this morning with the council member for, am I pronouncing that correctly, Mr. Duan? Okay, thank you. Mr. Duan's property here that we're talking about. We did hear from Councilmember Vo this morning, and Tom is going to fill us in on that.
I don't know a whole lot. Here's what I understand, that Mr. DeWant reached out to Councilmember Vo yesterday afternoon at 5 to ask for help and support in your appeal, and that Councilmember Vo really had not even been informed that this was taking place, and really, I think he knew a little bit about the owner and the management company's situation generally, but I guess, asked for a deferral so that I think, if I recall, what she said was that she can't support it unless she has time to really investigate it, between 5 o'clock yesterday and right
Yeah.
before this meeting, she did not have time to do that.
And she was not available to come to the meeting, and she didn't know
Correct.
this was on the docket for today. My understanding was, and this isn't going to take away from your time, but my understanding was that she was going to reach out to Mr. Duan and ask that he would voluntarily defer this. And I guess that was a no, which is, you're right, of course. And this isn't going to take away from your time. We're just doing a little cleaning up here before we get started.
Yeah, I did respond to that request explaining why it was extremely detrimental for me to defer this.
Yes.
And I could elaborate on why that's
Okay.
the case. when we're.
We'll get to
when we're at
that. That's
point.
just fair enough, that we just want to establish that the council member did communicate with the appellant, and made that request. She asked us to defer, or she would want us to defer so that she has time to get to a better understanding of the situation. And then because we weren't going to defer on her request, she said that she does not support, and correct me if I'm misrepresenting this, but I don't believe I am. She does not represent, or she does not support offering relief at this time because, in light of the fact that she does not have the information. She would not be supportive of the appellant at this time, not based on the merits of the case, but rather based on the timing.
And the lack of
preparation.
ability
Yeah.
to really give her honest opinion is what I understand.
So would it help to allow her the time to review the facts properly so that she can come to a more informed determination?
I will say that we take everything into consideration. We always take neighbors' communications with us very seriously. We have only had one or two occasions where we've had a council member come and support or oppose
Okay.
an appeal. I don't know if it would help. It may be quite detrimental, as you're fond of saying. So we don't know. I mean, it doesn't, if she was violently in support of your appeal, it would probably be somewhat helpful. It seems to us that we're usually open to, and I would think a council member's support would hold that kind of sway plus.
Okay.
But there's no guarantee that she's going to be supportive. So it's up to you, and here's Mr. Cash with more information.
As a council member myself, we always appreciate when decision makers, boards and commissions listen to our concerns, and because we're representing some of those neighbors too, right? They're our constituents. And so we have to think about not just the appellant, but the community at large. That said, I think the board here is going to decide on the laws and the rules, and that, you know, that a council member can help. But ultimately, I think they're going to look at the laws and the situation and decide based on that.
Yeah, I would just say it's sort of, given
Roll
that
your
you
dice.
don't know, it's a roll of the dice. You don't know that she's going to look at the information and then be supportive. So it's obviously up to you. It is a roll of the dice, unfortunately.
Okay.
Shall we
Because
proceed?
you could defer and then she comes and doesn't support it, and that doesn't help you. You could defer and she comes and does support it.
Okay.
Yeah.
I mean, given what you're saying that, you've reviewed the circumstances and they are quite extenuating, I think we're good to proceed, and I'm obviously here to make my case and ask for leniency.
Okay. Well, we'll start the clock then. You have 5 minutes. There's no opposition here for this case, right? There's no opposition, I think, for any cases today. You have 5 minutes to tell us about your situation, and don't feel you need to use all of it. Go right ahead. And start with your name and your address for the record.
This is Rahib Diwan, 1508B Phillips Street, Nashville, Tennessee.
Is that mic on?
Yes,
Okay, super.
it is.
I don't
Can
see
you hear
the
me
green-
fine?
Yeah, but I don't see the green
Should I
light.
speak louder?
Okay.
Okay. So, I've shared certain details about this case with you already. I'm sure you've reviewed and received the letter as well as the supporting documentation. I just want to point out a few key aspects of that. Obviously here today, because I'm in a very difficult spot, and I'm just requesting leniency and compassion from you all. I graduated last summer in Chicago for my MBA program, and I purchased this property management business from the previous owners in the summer of last year. And obviously, as I was transitioning on, I brought on some help to run the day-to-day of the business because it frankly became very overwhelming for me to manage everything. So I hired some third-party contractors to help with certain aspects of the operations, the day-to-day operations. And around that time, I had a lot of constraints on my time personally that prevented me from being extremely involved in the business as I normally would have been. And so I had delegated a lot of this responsibility to these team members that I had brought on board. And I frankly was not aware of this violation because I was not keeping an eye on that level of detail. I was keeping an eye on the reservations, and I didn't notice any reservation come through that violated this ordinance. I have shared the reservation details with the council members as well. And obviously that would have been a trigger to me that, hey, something came through that shouldn't be the case, and let's look into it. I never received any such booking, so it never got on my radar until it was too late, obviously. And the other piece is that obviously had I known about the history of violations that this previous property manager had, I would have been extra vigilant about this stuff and really made sure that I was very explicit with my team about what to do and what not to do and how to do it. But frankly, it didn't even occur to me when I delegated this responsibility that they would make these changes and trigger these violations. And frankly, it's obviously a very gnarly situation for me, because I used an SBA loan to buy this business, and now I'm in a financially very difficult position, right? Because if I'm not able to continue operating, then everything collapses, frankly. So, that's the gist of the situation I'm in. I've obviously supported that with a detailed letter as well as documents supporting my travel and the extenuating circumstances. I hope you had a chance to review and reflect upon that, and that's where I'll stop.
Okay. Mr. McBroom, did you have something to add? Or you're just, okay, wandering? Okay. Thank you so much for your time. Can I open this up to my colleagues to see if anybody has any questions? Ramon, why don't you go first?
Yeah. So I notice in the documentation you provided that if someone's interested in booking for more than 10 guests, they typically book both A and B.
That's
How
correct.
do they learn about, one, I have concerns about advertising for more than 10 guests, but how do they learn about the option for booking both properties?
There's a separate listing for that increases the occupancy accordingly, and that is following the guidance and ordinance provided by Metro Codes. So there are separate listings that list both permit numbers on there for both units, and that's the correct and proper way to structure that.
But the advertising itself, was that for more than 10 people?
It was, and that was what triggered the violation. Like I said, though, none of the reservations we received for the individual property ever actually validated that in terms of bookings or guests staying there. And I shared the complete history with you all that validates that.
Do you have a question, please?
Yes. What measures have you put in place to make sure that this doesn't happen again?
I obviously changed my team. I have been a lot more intentional about what I delegate and what I don't and how I delegate it, right? There's certain guardrails in place software-wise now that prevent people from even touching these things, right? So no other team member can even change certain aspects that might be sensitive, right? So obviously learning from this lesson, trying to manage this as best as I can and making changes to prevent any such circumstances in the past. This is my first violation. I've never been in trouble with Metro Codes before, right? So this has blindsided me completely, and obviously just trying to navigate this as best as I can.
You've never been in trouble before. Did you have involvement with Airbnbs and VRBOs before you bought this management company in 2025?
I did have a couple of properties, yes, and they've always been in compliance.
I'm sorry, say that again?
I have, yes. I had very limited experience. I had one property.
That you managed or that you owned?
I owned,
That you owned?
yes.
Okay.
Yes.
And is that here in Nashville?
It is in Nashville.
Let me ask, the graduate program you were finishing up in Chicago, was that an MBA?
It was,
Okay. And you bought a company,
yes.
and you had how many properties that you were going to manage?
26.
Okay. And 20 of them were violating from the word go.
No, not the word go.
They were over-advertised, according to Mr. Hargis.
Yes, but only late last year onwards when these contractors were brought on board and the responsibility was delegated. Prior to that, there was no violation as far as the advertising is concerned as well. So from April 30th to November or October, or at some point in November, when the changes were made, there were no, like, we were in compliance with our advertising guidelines.
Okay. Let me go back to talk about this property in particular.
Yeah,
You took on the management of this company, of this project,
yes,
this home,
yes.
as part of your company that you purchased, and it has a history of violations, which you are telling us you didn't know about.
I
I
was
get
not
that you
aware
wouldn't
of
know
that.
about it because you weren't involved. But
Yes.
those things are all listed online. And the due diligence, perhaps, was on you to investigate what you were taking on, what you were
I-
getting your hands into here.
I absolutely agree with that. That is a harsh lesson, and you know, obviously, hindsight is 20/20. Like, I did a lot of financial diligence, right? We looked at, like, the revenue and, like, the tax returns and the owner statements and all of that stuff. We did legal diligence in terms of the contracts that this company had with its homeowners and all of that. Honestly, this is something that was an oversight on my part that I didn't look into, and had I looked into it, obviously, my approach would have been very different.
So one of the issues that we're supposed to consider is really how this impacts public policy. And I think one of the letters that we received really did speak to that, because there's a history of noncompliance, at least with this property that we're talking about.
Could you share
And
the
it is-
details of that? Is it-
It's in the packet.
Okay.
Were they not, oh, you wouldn't get it? There's can you scroll up, Alicia, to the letters in opposition of this? I thought it was an interesting point, because, you know, as Nicole will be able, could probably quote chapter and verse, I can't, but, you know, if you scroll up right about here, history of noncompliance and prior revocation, you know, one of the goals of these ordinances is to keep people in compliance and encourage people to be in compliance. And when we give someone a break, it kind of erodes that. It kind of erodes that public policy goal. And this property was already committing these same violations. Another part of the public policy for these, it's not just safety for the number of people that's appropriate to have in a house. It's also the quality of life for your neighbors.
Right.
Right?
Right, absolutely.
And that is detrimental to them, to have 12, 14 people. So that is why those rules exist.
Right. And I
Right?
respect those rules, absolutely. Like I said, this was purely an oversight. We were never willingly violating any of these ordinances. And we never hosted larger parties that were in fact in violation of this limit, right? So I completely respect where you're coming from, but like the listing had this change, but it had no practical implication in terms of reservations or bookings or groups we were hosting. And completely respect the ordinance itself. I'm not trying to deny any of that. And I understand why they're in place.
Anyone else have questions? Please.
There are a couple of letters that have come in and and it seems like they're generally in opposition, and one, maybe three, and two.
Yeah.
Okay. And a lot of it is just kind of in general about short-term rentals. I think there was one that pointed out that there have been prior violations. And I'm sorry, 20, I know we're talking about one here, but there were 20 properties in all that you manage, is that right?
26.
26? Okay. I'm going to make a comment when we're in discussion, but, yeah, I just wanted to make sure that those letters, the couple of letters, and
Yeah.
one, like I said, one was more about the feelings about short-term rentals in general. Actually, two of them were, but one of them had kind of a more like, hey, this property has had violations, and seemed like they were pretty close to the property.
And at any point, am I able to review these letters and like?
There's one on the screen for you right now. This is the one that I was mentioning, where
Okay.
where the neighbor points out that there's a history of noncompliance at this property, and then points out that one of the public policy goals of the ordinance is to prevent these party houses which have really done a real number on some neighborhoods here in Nashville. There are neighborhoods that very few people live in anymore because of these party houses. So there is a goal there in
Right.
that it's not just to be strict. There's a
Understandable.
goal.
Right.
But then this person goes on to talk about the erosion of neighborhood character and social capital, all valid points, just not valid for this case that we're talking about.
Right.
If you scroll up, Alicia, there's another letter. Here. And this one is short and sweet, but does speak to the very issue, which is committing a regular violation of operating, or at least advertising to operate excessively. So the reason I want to point out these two letters and how specific they are is that often in the past, we do get letters the way that Mr. Cash just described, that are just general in tone. We don't like STRs. We, this
Right.
isn't good. This isn't good. We don't know who's coming and going. These two letters are actually very specific to the issue at hand.
Okay.
So they are specific to the issue at hand. They're talking about excess occupancy.
Yeah, but
They're
that's
not
what's-
talking about just,
yeah.
we don't like this.
Well, but that's also, I will just say, that is what's written in the notification to the, so like, yeah, we want the zoning administrator's opinion maintained based on violations. Like that's,
Yeah.
I would say that's not super specific for me, but yeah.
It's a lot more specific than most of the letters that we get, which are very general in nature and don't
Right.
actually speak, they speak to the issue as a whole and not to the property itself.
Right.
And these two do speak to the property this
I
time.
understand that there's pointing out to this property specifically and stating that, hey, there's been violations, but in my defense, during the period that is in question, when the occupancy limit was changed, we never violated it, in fact. Right? It was an advertising violation, but we never hosted any groups that violated that limit. And of course, I've shared the reservation history with you that confirms that.
Yeah.
Right? So I understand like the intent of this letter, but I want to provide that context as well.
The only thing I'll add is an advertising violation is a violation.
Oh, absolutely. I'm not denying that, right? And the problem has been rectified. Like I said, it was an administrative oversight under very extenuating circumstances. Obviously learned from it, made changes, put guardrails in place to prevent it from happening in the past and in the future. And we just want to obviously be able to continue to move in the right direction and course correct from here.
Just a quick question on, is this property located near the new Memoir building?
It is located close to it. It's located where Soho House is, where there's
Yeah.
that Flamingo Club is, and like
Right by the little art,
Say that again?
right by the little art shop on the corner?
Yes, the art gallery. That's correct.
Besides these two units, and this is probably not germane, but it will help with my clarity of the situation. Besides these two units, are any of the other units under your management as well?
They are. There's four homes in a row there. They're under the same management company. And just to clarify a comment about what was said earlier about Visit Nashville Now, yes, the listing still mentions Visit Nashville Now, but I retained the brand assets, right? It's not like I changed the name or anything. I just, management transition, but the name of the company did not. So I took over the social media assets and the website and all of that along with the acquisition.
Okay. Any other questions before we discuss this amongst ourselves? Okay, Mr. Dewan, thank you so much for your candor and your information. We are going to discuss this. You can stay there, you can go back to your seat, whatever you like.
Thank you.
Okay. Who would like to start? Go right ahead.
So I'm glad that the applicant shared with us that there were no actual stays that were in violation of the ordinance in terms of the size of the party, because that is helpful for me when thinking about how granting relief would affect public policy. Obviously, the ordinance says what it says. Advertising in excess of the approved occupancy is a violation. I do think it's a little intense to talk about how this is like a party house with a history of repeated violations. Like, this is a second violation. They corrected it the first time and it wasn't under this particular management. He did have a due diligence requirement to look into that. I completely agree with that. But there's no evidence of complaints from neighbors about noise, about too many cars, any of the things about people throwing up in the front yard, which we see on other cases, bodily functions, all that, any of the things that I would associate with a permanent party house, we don't see any evidence that that's actually happening. So personally, I'm not concerned about how granting relief on this particular application would erode public policy, because the point of saying don't advertise excess occupancy, there's a safety reason, obviously, and there's also the, like, wanting to avoid party houses. And I see no evidence of any safety issues or of any party house behavior with this property. So I'm not super concerned about that. I am comforted by the fact that the applicant has put in place, not just, standards of practice, but also software elements to prevent things like this from happening in the future. That's always something I'm going to look at. What steps have they taken to remedy it, and how are we going to make sure it doesn't happen again? Obviously, if this came back to us again, I would not be inclined to offer much relief. But I am convinced by the diligence that the appellant has shown, not only in his presentation today, but also in sending us very detailed documentation of, like, this is the situation, this is what happened, this is why it happened. I am convinced that this is not a bad operator. This is not the sort of person that the ordinance was designed to be so punitive for. And so I would be open to offering some type of relief. I don't know exactly how much yet, but those are my thoughts.
And just to confirm, we're talking about the last day was in December, is that correct? Hold on.
January, because the revocation letter was sent in January.
Okay. So the last day was in January, and
And there were no stays since.
yeah, and it's supposed to be 1 year, correct?
Correct.
Okay, just so we know where we're starting from.
I'm in agreement with Nicole, in that I think that the fact is that there was a violation of the advertising, whether it was intentional or not. That's true. The fact that there was a prior history with this property doesn't really affect me that much, because I understand a lot of the mitigating circumstance. And I do think that the appellant has acted in good faith to fix this problem, and so this is also what we want to see. And so I am also inclined to provide some kind of relief.
Ron?
So I'm trying to balance my comments here because, and set my political views aside, because, a block of 4 houses that are all Airbnbs offering 10 units each, that's a party house. Like, even if everyone is staying in their own separate house, like, no matter how you slice it, it's a party house. But setting that aside, because Metro Code allows that.
Right.
I do think Mr. Dewan has taken some necessary steps to remediate this. I'm a little uneasy on, how you actually get up to 16 people in the 2 houses at the same time who are with the same group, where it sort of goes back to that whole party environment that Metro's trying to remediate. But again, setting that aside, looking at the code as it is, it's a violation of the advertisement. Some steps have been taken to rectify it, so I'm willing to grant some relief. I just couldn't let it go without stating,
There are a lot of those,
I know.
mean, there's no shortage, right?
I
of
just
these.
happen to know this one.
Yeah.
That's why.
Okay, yeah. Yeah, I don't disagree with anything you guys are saying at all. I think it's getting, I'm sorry, Tom, I'll give you 1 second. I think it's getting a little tiresome to have every other person come forward and blame someone else, right? It's never anyone's fault. It's the management company. I hired a new management company. It was I hired an assistant. We got rid of her. There's, I think it was the last meeting, every person that came up here, we were like, that's another job lost, So it's just become, and if you're taking on a business that's got 27 units, you got to be looking at more than the financials. You got to be looking at being a good operator, a good neighbor. So it's become tedious to hear nothing's ever anyone's fault. It's always your management company, or if you're a management company, it's always your employee. If you're an employee, it's, my assistant, right? It's just, we hear it a lot, and it'd be nice to not hear it so much. But that doesn't mean I'm not going to offer relief, and it doesn't mean I'm not open to being convinced. And Tom, go ahead.
Thanks. I was just going to chime in and say, I agree with what others are saying. I think that, the ad was wrong, but we have neighbors saying there have been violations, but we don't have specifics about problems. And I believe I believed what the appellant was telling us. He seems honest, and I think that he'll do better. I was going to say, with this 27 unit, I was going to say this, but it really makes more sense to an owner that that's a lot of folks, that's a lot of Nashville, and I don't know what the relief's going to be. So I just want to say, if there are some vacancies for whatever reason, please consider, some long-term rentals. We got some Nashvillians who could use some. Thanks.
And I did want to say, I do feel like Mr. Dewan is taking accountability. Obviously, he's telling us what happened. He didn't personally do it, and also he's not going to fire himself. So I get what you're saying 100%, but I don't know what else he would do when he wasn't the one who personally did it. He is saying, I get it. I'm not trying to operate in bad faith, and I'm taking remedial steps.
I would say he'd abide by the 1-year waiting rule to reapply.
Oh, well, he could, but we exist to consider these cases. I mean, I think you can operate in good faith and still ask for relief.
And I think we can consider some. What do you think is palatable to you if we were to offer some relief?
I'm going to start with the two who are more in favor.
Okay. Let me start with Mike. What would be more palatable for you?
Sure. If it's not less than a year, I would start with 6 months. From, I guess, January was when the revocation letter was sent, and obviously that the zoning administrator did not err.
Does 6 months sound like something you can live with?
Yeah, I would be more lenient, but I know that there's not an appetite for it, so I'm not gonna try, just for the sake of taking a stand.
That's very wise. Would you like to make a motion? Or
No.
do you not want your fingers on
No,
that
no.
one? Okay,
I
I'll
won't
make a
be
motion.
making a motion.
I make a motion that the zoning administrator did not err in this case. Nonetheless, we will offer a bit of relief 6 months from the date of the last violation, which was, do we have a date? January 9th?
The 6th
January
was the
6th.
revocation letter.
Okay. So let's say January 6th. 6 months from January 6th.
Second.
Can I see a show of hands? We have 3, 4. Can I see against? We have 1 against.
Yeah, and just to be clear, I'm voting against because I want more relief, but I'm glad that we have a majority.
Okay. So, at least you caught that. It was, I made the
did.
motion, Ramon seconded it. Mike, Ramon and I voted in favor. Yep. All right. So, Mr. Dewan, you heard that, and you can follow up with the team at Metro. Okay. Next case.
Chair.
Yes.
Chair, I need to say something.
Please.
I'm sorry for this.
No, you're fine.
But I have to leave, and I'm glad that you all have a quorum, because it would kill me to leave and but I have a family health thing and a big
Go with
meeting about
God.
development tonight. Thank you.
Be on your way. Okay. I know, someone bar the door. No, I'm kidding. Okay, super. Moving on.
Our next case is 2026-006, 202 Bonnalynn Drive, William Alpsteg. It's an expired permit. The property operated as an STRP with an expired permit. This is governed by BL 2020-187, 6.28.030.8.5.L.6. Upon determination by the zoning administrator or the zoning administrator's designee that the short-term rental property is operated without having renewed a previously issued permit, there shall be a waiting period of 6 months from the date of such determination by the zoning administrator or designee for the property to become eligible for an STRP permit. The board has discretion under BL 2023-136. On July the 20th of 2018, William Alpsteg acquired the property at 202 Bonnalynn Drive, Humphreys, Tennessee, 37076. On July the 11th of 2023, an owner-occupied STRP permit application was submitted for the property. On July 27th, 2023, the permit was issued. July 31st of 2024, the permit was renewed. July 28th of 2025, Administrative Officer Alicia Buffer sent a reminder email to the applicant, contact, and owner listed on the permit, all of which was for Mr. Alpsteg. And the email asked, your STRP for 202 Bonnalynn Drive expired on July 27, 2025. I'm inquiring to see if you're planning on renewing your permit for this year. Please renew. There was no response. On August 27th of 2025, Administrative Officer Buffer sent the final email reminder to the applicant, and it was for your STRP for 202 Bonnalynn Drive expired on 7/27/2025 and is now beyond the 30-day grace period and cannot be renewed. Please contact David Frevitt at his email address regarding your expired permit. On December 2nd of 2025, the address for the property appeared on the monthly list for November provided by Granicus Host Compliance of properties operating with the expired STRP permit. Inspector John Phelps verified the website advertisement was posted and the property had operated after the STRP permit had expired. Inspector Phelps sent a notice of violation to the appellant. January 15th, 2026, the advertisement remained posted and there was a documented stay in January. Inspector Phelps made a site visit to the property, posted a stop work order on the door, which was documented with photographs. January 21st, 2026, the appeal was filed. There were no complaints on the Hub Nashville. There was one email on February the 9th, 2026 in opposition to granting the appeal, and there was one email on February 28th, 2026 in support of granting the appeal.
Great. Any questions for Metro? Mr. Alpsteg? Yeah. Are we butchering your name? I apologize profusely. Okay, good. Come on up. Oh, hang on one sec. So no questions for Metro? It's okay to move on to the appellant? Okay. Have a seat there. Sure, great. Yeah. You can have a seat right there, and you probably picked up what the gig is here. You're gonna open that mic if it's not already open. You are going to tell us your name and your address for the record, and then you have 5 minutes. Do not feel you need to use it all to tell us about your situation.
Pretty short, so
Okay.
I don't think it'll take that long. My name is William Alpsteg, and the address is 202 Bonnalynn Drive. I guess, just to kind of bullet point it, on, I forget the exact day in January, I think I was actually gonna leave my car there to go out of town, and saw the notice on the house, got it, read it, looked at everything. I was kind of shocked to see that, but I looked at the rules, followed everything I needed to follow, to kind of
go into it, I guess at that point I was, you know, I fully thought that I had renewed. That email there on that sheet is the one I had that I was going off of. My email is so full of stuff around, you know, that summer. I did all kinds of spam blocking, which could have also come into play in this situation. But yeah, long story short, I, you know, thought I had renewed. I had been operating the whole time with that assumption. I know it'd be absolutely stupid to try to do it without it. I know you guys have everything you need to see what people are doing, so it would, yeah, not be a wise thing. So yeah, once I got that notice, I, you know, checked in with, I forget his name at Codes, and found out what I needed to do, what they needed, did everything I could. The biggest thing that I probably kicked myself about is I've always been very proactive about follow-up emails. The years before, I'd always email and check and make sure they got everything, and this is like the 1 year I didn't do it. That's exactly, I guess, how it goes. So yeah, and then going forward, and even with this process, I've always followed up on everything, and my plan is to just follow up on everything, make sure everything is, they got everything, everything's good, and that's, I guess, as simple as I think the whole thing is, and yeah, that's the situation, I think.
Okay. Any questions? Please.
So looking at the information that we received, it looks like there were 17 stays after the permit expired. Could you explain?
Yeah, this is before like January of 2025, is that right?
Leading up.
Yeah, it would be the case because I wasn't aware that I was even non-compliant until I got that notice. So I thought the whole time I was operating within compliance. So yeah, that would make sense why. And the minute I saw that and reached out to Codes, I made everything 30 days, blocked off the calendar, did everything basically that they needed. So yes, that would make sense that was on there because I thought I was in compliance that whole time.
Okay, I'm seeing that that Codes sent you a notice of violation in December. Did you receive that notice of violation?
I think I did, but I probably didn't. I get between the two houses. This is our rental house, then we have our home house. So between the two houses, we get a lot of mail, and it probably takes me a couple weeks to get into it. So I probably got it around the same time that I actually went to the house and saw the notice on the house. They were probably around similar times. And so the minute I had the notification that there was an issue, then I did everything I could to fix it.
Okay, so you don't live there?
That is, I guess, kind of, we have a house in Lebanon and we have a house in Hermitage. And so we kind of switch off, but we're in both spots.
Okay, but you
And
said this
that
is your
house
rental house?
It's the rental house, yes. The other one is our family's house.
Okay, thank you.
Like, we can stay at the other one when no one's there, but, yeah.
So I don't want to open a new kettle of fish here. Can of worms, kettle of fish. I'm mixing my metaphors. But is this,
I think we have to rule on what we have
I
in
know,
front of
I
us,
know,
and
I
then
know,
Codes will
I know.
consider.
We're gonna, yep, 100% correct. All right, so I do actually, if I can just quickly confirm with Metro, with either Alicia or Mr. McBroom. This is interesting. We've never seen this before. I'm gathering that if you look at, do you have a copy of this letter from Mr. Alpsteg?
I
How's
do.
that? Alpsteg, not bad?
Yeah,
Okay,
you got
good.
it.
Whew. As you see in the email there, it is a little confusing. Subject, renewal notice, short-term rental permit expires 8/26/2025. I think we can probably surmise that is the end of the grace period. But you can see how it would be confusing, right? That if we know there's a 30-day grace period and you see one email, not 4, and this one says permit expires 8/26 and you log in on 8/27, you're gonna think that you are on day 1 of your grace period and not day 1 of your out of luck period.
Yeah, the year before, I know I renewed in the grace period, so I always thought I had that.
To set some reminders in your calendar.
Exactly, yeah.
Have you done that?
I usually do, yeah,
Might want to do that right now.
but absolutely.
Do you see that, Mr. McBroom?
Yeah, I don't have copies of the emails from previous year, but you have in your.
I have an email here. I have one where I would I should have some follow-up ones I have.
I mean, I don't have our copies of them.
No, I know, but this is simply what I'm trying to point out, that this is a screenshot of what that email is. And it says that the permit expires 8/26. So you can see the confusion. He thinks 8/27 is day 1.
Well, I would have to take issue with that due to the fact that in your summary for this year's emails, you can see it's very clearly stated as to what the dates are. And without being able to confirm that from our end, I just can't lend the credence to it.
All right. Any other questions, guys? Well, let me just clarify then, Mr. McBroom, do we ever send, do we, not we, but does Metro ever send emails that note the date of the end of the grace period in the subject line as opposed to the end of the actual proper permit period?
No, it would be noted in the body of the email, not in the subject.
Do you have a copy of that email?
Yeah, I can forward it all to whoever I need to forward it to, if that
Yeah.
helps.
I think just for like a housekeeping matter going
Yeah.
forward, it would be useful to have that.
Yeah, I can save it or
If you-
PDF or whatever you need.
If you look in your summary, though, you'll see how the emails are formatted. Let me scroll.
Okay.
This is the first email noting the expiration,
Right.
and then this is the follow-up email noting the beginning of the 30-day grace period.
Yep. I know, I'm just looking at something from no reply, no underscore reply at nashville.gov, which if, granted, this is what the appellant is telling us, this is the only one he saw. That's not your problem, I get.
Yeah, I can't identify that email without some research.
Okay. Can you forward that back to David or whoever you've been
I
communicating
think
with?
I did give it to David
Okay.
originally, when I was
you
back and
did.
forth with him. Yeah,
I
yeah.
see, that's exactly what it is.
Yep.
I'm not saying that, oh, you're off the hook because of this.
Oh, no, yeah.
Far from it. I'm just saying that this is actually something we should probably just take note of going forward. But
Yeah.
again, all of these emails are, I think just a courtesy. Like,
Yeah.
this is not,
I'm
not you
not,
got the email or saw the
I'm
email.
saying a lot, I mean,
Sure.
most of it's on me for, plenty of, not following up, probably not being as organized as I could be, and, so, yeah, I take ownership on that, I've kicked myself plenty over it.
all right. And on this ordinance, it's a 6-month waiting period, but we're looking at, is that correct? Yep, 6 months waiting period, but we're looking at January 15th, perhaps?
And I have the last guest that was there. I think I think it was a New Year's guest was the very last guest. And then as soon as I found out, I blocked everything off and made everything 30 days.
As of January 15th, the ad was still posted. Does that sound?
I think I went in there and did some settings that I thought I had it. Like I did 30 day, but I think there was one that I didn't do right. But everything was blocked off at that point. So it may not have been officially like the settings 30-day, and I think David said something about that, and I double checked, and he was right. But I had everything blocked off so nobody could do anything, and canceled all future guests at that point.
All right, and then we do see we have two letters kind of cancel each other out here, one for and one against, and not a lot of specific.
I thought the one in support was very specific to this property.
Well, it was about
Yeah.
financial hardships and what have you, but
But also that they've been a good
been a good
operator.
neighbor.
Yeah.
We have
Yeah.
great relationships with our neighbors and keep in touch, ask them how the guests have been. I don't know if it matters. I'm curious on what the bad one might have been, but every neighbor I've talked to, I always ask them how the guests have been and make sure everything is fine for them.
This one, we can scroll down to it. It's page 30 out of 40. It really just speaks to the issue of short-term rentals as a whole. It
Okay,
isn't really specific to
that
your-
I
to your
understand that,
property.
yeah.
Okay, any other questions before we discuss this amongst ourselves? Nope? Okay, thank you so much for the information. You're welcome to stay there, go back to your seat, what have you.
I
And-
appreciate and just ask for any possible grace, and thank you guys for your time.
Okay. Oh, and we're not going to decide on this
Okay.
I'm sorry, we are going to decide on the issue at hand. The issue
Yeah.
at hand is operating after a permit expires.
Okay.
But I think that you should take note, if it's fair to share with you, that
please.
you've shared with us today that your permit, the permit that expired is an owner-occupied permit. And you shared with us today that you don't really live there full-time. And that is not what those permits are intended to do.
Okay.
So when you are granted relief to reapply,
Yes.
we can't guarantee they're gonna give you a permit.
Okay.
Because the permit you had, there may or may not be non-owner occupieds available, in that area. And because of that, you may not qualify.
Okay, I guess
So-
I'd like to just understand the
Sure.
difference, because when I did it, I thought I was doing what I was supposed to be
Uh,
doing, but,
My point is, there's a matter at hand that we're going to debate
Okay.
and discuss. And when you go back to get your short-term rental permit,
Mm-hmm.
reissued, renewed, what have you,
yeah.
that matter is likely going to come up.
Okay.
So just be prepared for that.
Okay, yeah, and
Okay.
I'll do whatever needs to be done.
And we're not,
Yeah,
we don't have a dog in that fight. I just want you to be prepared.
okay, yeah,
Okay.
I just want to know everything I can about it.
Okay. Thank you so much for your time. Okay. Ramon's got a green button. What do you have for
Yeah,
us?
I think my sticking point is the number of stays after the permit expired.
Yeah.
He was aware of the expiration date. And that's where I'm stuck a little. I think everything else I can handle. I'm willing to grant some relief. It's just that piece that's kind of the sticking point for me.
Okay.
Yeah, I would agree, Ramon, and I think, obviously, they're, looking through what he's explained, what happened. I do think that he thought he had done something that he didn't do, but it's also important to double check that stuff when you get weird messages that don't make sense. So I'm troubled. I can't recall a case recently where we've had an expired permit and there were 17 stays after it expired. Like, that's pretty extreme, given what we usually see is 2, 3, maybe 4. So this feels like a case where I don't know that I would offer a lot of relief. I honestly don't know that I would offer any
Really?
relief. We're halfway through the period, almost. So it's like, at this point, we're already 3 months in. If you're starting in January as sort of the starting point, and 17 stays. I understand he did take action when he learned of it, but his renewal didn't go through. I mean, he got a fail notification on the website. I don't necessarily know how you interpret that to be that my renewal was successful. So,
I agree. As a short-term renter owner, I'm always excited to see when Metro cashes my check. Because of the number of stays, that's our sticking point after the expiration. I think if this was more of a typical ruling where we had a year, I'd be more inclined to say 6 months. Because it's 6 months, I'm inclined to say that there's no error and leave it as it is.
Would someone like to make a motion?
I move that the zoning administrator did not make an error.
And that we're offering, do
That's
we even
it.
need to say that we're offering a relief?
I think only if we are. Right?
The zoning administrator did not err. Can I hear a second? Second. Can I see a show of hands? Great. So that was 3, and against. I would have just offered a little bit of relief, but it's no big deal. Ms. Buffer, that was, Mike made the motion. Who seconded? Nicole seconded. All but me. There we go. Thank you so much for your time today. We really appreciate it, and we wish you the best luck. Okay, next case.
Our next case is 2026-007, 1300 Gartland Avenue. Fran Patton, expired permit. Property is operated as an STRP with an expired permit. It's an R6 zone district. This is governed by BL 2017-608, effective date February 2nd, 2018. Section 17.16.250.E.L.6, number 2, upon finding by the Board of Appeals that the short-term rental property is operated without a permit, there shall be a waiting period of up to 1 year from the date of such finding. For the property to become eligible for a STRP permit is determined by the board. The length of the waiting period shall be based upon whether the operator was aware or unaware of the requirement that the STR have a permit. Evidence to be evaluated in making this decision may include, but is not limited to, testimony of the operator, testimony of neighbors or others with knowledge, evidence of that the operator was informed of the requirement and disregarded the information, evidence that the operator had looked into requirements and misunderstood them. Prior and repeat offenses by the operator under this section, and whether the operator, upon being informed of the requirement, obtained or attempted to obtain the permit before renting the STRP again. The board has discretion under BL 2023-136. I go through that due to the fact that this is governed by 2017-608, which this is prior to the distinguishing of operating without a permit or operating with an expired permit. So it carries an up to 1 year wait period depending upon your decision. On August the 11th, 2006, the appellant acquired the property at 1300 Gartland Avenue, Nashville, Tennessee, 37206. November 20th of 2018, an owner-occupied STRP permit application was submitted for the detached accessory dwelling unit, DADU, on the property by the appellant. On December 14th of 2018, the application was processed and the permit was issued. The permit was renewed in the years 2018 through 2024. The permit, December 14th, 2025, the permit expired. December 15th of 2025, Administrative Officer Alicia Buffer sent email reminder to the owner, contact listed on the permit. And it read, your STRP for 1300 Garland Avenue expired on December the 14th, 2025. I'm inquiring to see if you plan on renewing the permit this year. If yes, your 30-day grace period ends January 14th, 2026. Please renew. January 14th of 2026, Administrative Officer Buffer sent a final email reminder to the owner listed on the permit at the email address on file. However, Administrative Officer Buffer referred back to the permit and found that Ms. Patton was listed as the owner contacting the applicant, and the email address listed for the owner and contact was recorded as fran@nashvilleisgreat.com, and the email recorded for the applicant was franpatton@bellsouth.net. She sent emails to both email addresses. The email stated that the grace period had ended, and for further assistance, please email Inspector David Frabin. On February the 3rd, 2026, the appellant, Ms. Patton, emailed STRP renewals at nashville.gov mailbox when she realized she had failed to renew the permit. Unfortunately, the 30-day grace period had ended 20 days earlier, and there were 4 documented stays in January. Inspector Frabin had to inform her that she was subject to an up to 1 year wait to reapply because the permit is governed by BL 2017-608, as cited earlier in the summary. February 10th of 2026, the appeal was filed. There have been no additional stays. There were no complaints on the HUD Nashville or the STRP hotline. There were 2 emails on March 4th, 2026 in opposition.
Okay. Any questions for Mac before we hear from the appellant? No? Okay. Ms. Patton, come on up. Have a seat there. Is that microphone on already?
There's a green light.
Okay, it's on. Give us 1 second. We'll just get these papers and then we'll get started. Thank you. All right. So you have 5 minutes to tell us about your situation. Don't feel you need to use every minute of it. And I'm sure there'll be questions. So anything you forget to mention probably will come up in conversation. So
Okay.
go right ahead. Oh, I'm sorry. Start
I'm
with
Fran
your name and
Patton.
your address for the record.
Yes.
Thank you.
And I've lived at 1300 Gartland Avenue for 13 years, for 20 years, sorry. And I love and value my neighborhood. I love my neighbors. I have a little studio apartment in my backyard, and I've always felt it was the highest and best use for Airbnb because it's entry from the alley, parking in the yard, no parking on the street, 1 or 2 people. And in all the years, I've never had a complaint. It's an important part of my income with Social Security to pay for my house that I love, even if it is 100 years old. And this was truly a good faith mistake. The Bell South, if any of you are Nashville natives, you know Bell South went out of, like decades ago. That's how old that email is. I don't recall ever seeing an email to Nashville is great. If it came, I overlooked it, but definitely I haven't received anything for Bell South for years. Nevertheless, it was my fault that I didn't put it in my phone calendar. But I really, truly, with no ill intention, was bopping along thinking everything was good. I had a buy, I don't know if it's a buy or dual monthly. When this happened, I had a guy staying there for 2 months. And I think that's one reason it wasn't on my radar. So after all these years, I think I've had this Airbnb for 13 years, always paid my permit, everything good, kosher, no complaints. And all I can say is in all good faith, it slipped my mind. And I would really value consideration for that and immediate relief because it is an important part of the basis of my income for my home. And I'm hoping that with my neighbors supporting me so much, my long-term residents in this neighborhood and my good record, I would ask that you give me some grace on that mistake that I made.
Any questions for Ms. Patton? No? Okay. I think we're going to discuss this amongst ourselves. If you want to stay there, that's super, and if you want to head back to your seat, that's fine too. Okay. All right. Ramon.
I live for these cases. Long-term Nashville resident renting a DUBU, DADU. This feels like an honest mistake. You've renewed 6 years on schedule. No complaints, letters of support. I'd totally be in favor of granting full relief.
I agree. I think this is sort of the exact situation that the council envisioned as like a benefit to the neighborhood and not a detriment. And I think you see that in the letter of support from Ms. Patton's neighbor, which they went to the trouble of getting it notarized. So very serious about it.
I have wonderful neighbors.
Yeah, and I don't have any concerns about offering essentially immediate relief. It clearly was an honest mistake. I understand having someone there long-term, you sort of forget, you're like, oh, it just seems like things got out of a cadence, and there was no intention and no harm was done to the neighbors, or anything like that. The opposition emails were very general, form emails, just like, we can't have short-term rentals. But I always find it interesting when we have short-term rentals that have been operating for
one notices.
years and years, and it's like nobody noticed.
Yeah. Those are the best.
Yeah.
My neighbor said
Ma'am,
she
I'm
didn't-
so sorry, the public hearing isn't open.
I
We're-
apologize.
That's okay,
Yeah,
we're
it's
just discussing
totally
this
fine,
amongst
but I
ourselves.
do see in the letter of support that it took the neighbor several years to realize it was a short-term rental because it
Absolutely.
was so responsibly managed.
Yeah, and just to point out too, there are 2 emails, but it's the same email from the same person. So it's really just one, and it's general, and again, it's, this is obviously someone who hadn't even noticed that there was a short-term rental there, which is ideal. I think, as someone who once lived in a neighborhood that was littered with them, when you have a dadu, that's the best. Or a granny apartment, mother-in-law apartment, something like that. That's the best because that person's got skin in the game. So, yeah, I'm with you guys. I mean, you're a Monday kind of guy, right?
Yeah.
Yeah. What do you think? Monday? How does that?
I agree. I actually live, for the last 22 years, have lived about a block and a half to 2 blocks from the appellant. And we've never met. I'm saying that very clearly. I don't know the appellant or the specific neighbor, but I've not noticed it to be any kind of an issue. And obviously, my ears are up for local violations. So I see no problem with allowing a reapply on Monday.
All right. Well, I'll make a motion that the zoning administrator did not err. Nonetheless, we are granting Ms. Patton the opportunity to reapply come Monday, the 30th of March. Do I hear a second?
Second.
Can I see a show of hands? Very good. Good luck to you, Ms. Patton. Thank you so much for your time today.
Thank you. May I ask, I don't know what to do now.
Speak with these learned folks. They will help you out.
Thank you.
Actually, yeah. Okay, because we have one more case, so let's get to that. Do you have to go?
No, I'm just stretching.
Okay.
For a second.
You can't go.
This is 2026-0087, 52 22nd North Court. Samuel Maloney, expired permit, property operated as an STRP with an expired permit. Governed by BL 2020-187, 6.28.030.A.5, Roman numeral 1, expiration and renewal permit. An STRP permit shall expire 365 days after it is issued unless it is renewed prior to its expiration. 6.28.030.A.5.L.7, number 2, on determination by the zoning administrator or zoning administrator's designee that a short-term rental property is operated without having renewed a previously issued permit, there shall be a waiting period of 6 months from the date of such determination by the zoning administrator or designee for the property to become eligible for an STRP permit. The board has discretion under BL 2023-136. August 13th, 2020, the appellant acquired the property at 752 22nd North Court, Nashville, Tennessee. July 31st, 2023, an owner-occupied STRP permit application was submitted for the property. August 12th, 2023, the application was processed, the permit was issued, and the permit was renewed in 2024. August the 12th of 2025, the permit expired. August 13th of 2025, Administrative Officer Alicia Buffer sent an email reminder to the owner and contact listed on the permit at the email address on file. The email stated that the permit had expired on August the 12th of 2025, and the 30-day grace period began on that date. There was no response. On September the 11th, 2025, Administrative Officer Buffer sent a final reminder email to the owner listed on the permit at the email address on file. And the email stated the grace period had ended, and for further information, please email Inspector David Frabbit. Again, there was no response. On December the 12th of 2025, the address for the property appeared on the monthly list for December provided by Metro's compliance contractor, Granicus Host Compliance, of properties operating with an expired permit. Inspector John Phelps verified that the website advertisement was posted and the property had operated. After the STRP permit had expired, Inspector Phelps sent a notice of violation to the appellant. It appears that there were no documented days after the appellant received the notice of violation. On Friday, January 16, 2026, the website ad remained posted. Inspector Phelps made a site visit to the property and posted a stop work order, which he documented with photos. At 8:13 p.m., the appellant emailed Inspector Phelps about the stop work order that was posted. And again, this was a Friday night. And then we had a little thing called the ice storm. February 9th, 2026, the appellant emailed Inspector Phelps to follow up on the next step, and Inspector Phelps emailed that he needed to email Inspector David Frabbit. On February the 10th, Inspector Frabbit emailed that the permit expired on August the 12th, and the 30-day grace period ended September the 11th, and there had been 7 documented stays after the permit expired, which carried a 6-month mandatory wait period to reapply. Also, Mr. Maloney had the option to file an appeal. February the 11th, 2026, the appeal was filed. There were no complaints on the Hub Nashville or the STRP hotline. There was one email in support of the appeal on February 27th, 2026, and there was one email in opposition to the appeal on March 10th, 2026.
Okay. Does anyone have any questions for Mr. McBroom before we hear from the appellant?
Did the ice storm have any impact on the length of time between informing Mr. Maloney that he could apply for an appeal?
Oh, yes, sir, it definitely did. We were out of work for approximately 6 days now. We were instructed prior to the ice storm to take our laptops home with us, but there was a little issue of people not having power, so that complicated the matter. But yes, that's exactly the reason for that gap.
So would it have been possible that he may have been able to make the last meeting had Mother Nature not been so cruel?
I don't know. I'd have to look into that. I suppose it's possible, but I don't know.
February 9th.
I don't
So
have.
the appellant emailed first on the 16th of January.
That's correct, after
Okay.
the stop work order was posted.
All right, so. Okay, any other questions? Great. Mr. Maloney. All right, great. That microphone is open?
Yes, ma'am.
Terrific. So if you would just start with your name and your address for the record and tell us about your situation.
Yeah, I just have notes here. So
Sure,
I'm
go
gonna
ahead.
bring my phone, but, yeah, I'm 752 22nd Court, Sam Maloney. Just requesting relief, but first I want to acknowledge directly definitely the permit expired, continued operating. Beyond the grace period, I take responsibility for that. I just didn't know it had expired. During that time, I was dealing with a pretty significant disruption related to a property that I split time in Florida. Like the whole house was hit by Helene. So we actually have been rebuilding that, but I kind of split time back and forth. That's why I do the short-term rental for here. But born and raised in Nashville, complete, like family lives here, so I have to have a property to come and like visit all my family when I live here. So I'm probably here about half the year, definitely. Yeah, the home in Florida has been a lot of my concern recently just because it's just a decimated house. Trying to rebuild that while paying a mortgage on it. So, yeah, just trying to handle that as soon as possible. But I also lost a box of files with that. So that was kind of like my whole organization with that. But yeah, definitely understand compliance is definitely still my responsibility. So I would have corrected it immediately. Since being notified, I stopped accepting new bookings, trying to take the steps to ensure full compliance moving forward. But yeah, like I said, Nashville run, owner occupied. It's not operating through a trust or a property management company, it's just me. So I take pride in maintaining it. My next door neighbor is the one who I think supported an email there. But yeah, he's the only one that actually has a house bordering the property. And he's told me that he never hears anything from the Airbnb. When his family visits their newborn baby and whatnot, they stay there. So yeah, definitely not asking like bypass the rules, just asking for the opportunity to make, correct a mistake. But respectfully ask the board to consider allowing me to reinstate my permit.
Any questions? Not a question, but I do want to tell you, just having read the packet, I wanted to thank you for how respectfully you treated the staff and how thorough and respectful, for lack of a better word, your emails were in your communication with staff. So thank you for that.
Yeah.
Yeah, that certainly matters, and I think it demonstrates that you take this seriously. I actually did have one question. So I saw that there were 7 documented stays after the permit expired, but none since the notice of violation was sent. So was that because you didn't know that the permit had expired, but once
Yes,
you
ma'am.
got notification?
Yeah,
okay.
I've been in Florida since December, so I hadn't been at the house. I had a guy staying there for 60 days from January through February, and he actually sent me the notice on the door. So that's when I immediately I sent the emails and whatnot and did all that.
Thank you.
Great. Any other questions? Okay. We are going to discuss this amongst ourselves. I don't want to open a can of worms, but you do have an owner-occupied permit, so when you go back to discuss reapplying, just if this issue of Florida comes up and you're living in
Well, it's
Florida.
180 days.
Okay,
that I'm allowed,
but
yeah.
all I'm saying is just be prepared.
Oh, yes, ma'am.
Okay? That's all. We're not gonna, that's not the matter before us, but since you mentioned it today, it may come up when you have a visit with
Sure.
them. So just for your own edification, okay?
Like my driver's license, everything, okay.
We're not that's not
Got it.
not even an issue for us to discuss today. I'm just telling you, when you have to revisit with these folks, just be prepared to address that, okay?
Sure.
Cool. All right. We are going to discuss this amongst ourselves. You can stay there. You have the whole room to yourself, whatever you like. Okay. Who would like to begin?
I can start. I think it makes sense why he didn't realize that the permit had expired. He's obviously not attempting to circumvent the permitting structure because he's got a permit and he's renewed it before.
Right.
So clearly he's not trying to operate in the dark. I think it was a case of, like, a series of unfortunate events just piling up, which makes a lot of sense to me. You know, the 7 documented stays, it's not great, but there were no stays once he did receive the notice of violation. And as I understand, there was a long-term tenant staying there at the time. So I would be inclined to offer some amount of relief. And I'm open to discussion about what that would look like.
I completely agree. And I think too, look, this is someone who's been operating since 2020 with no complaints. That's great. That's a great track record. And I think too, conceivably, we don't know, but conceivably, right out of the gate, you know, we had the unfortunate, what are we calling her, Fern? The storm that may have already delayed this by a month. So I think even if this wasn't a winnable appeal, I would probably take a month off just for the ice storm. But I definitely think this was, you know, this is exactly the kind of case you want to see. You know, treated the staff with great respect and was very thorough, looking for anything he could do to come back into compliance. So
I agree. I think that this is the kind of operator that we like. And, you know, one of the things that I'm really conflicted when it comes to showing that a permit has been renewed in the past. I'm always conflicted when and then forgetting to renew it at this time. I'm always conflicted when we see that, because we do occasionally see that. Sure. In that by renewing it, it shows, you know, the effort to comply. But then by renewing it, also strikes against, the appellant in that you renewed it in the past, how come you didn't renew it again? So I'm not really sure exactly where I stand on that, if that's a positive or a negative. But it does show that, at least in the past, the appellant, it shows that this is a one-time thing. And, I think generally that kind of tips me towards an attempt to stay in compliance.
Yeah, the only thing I'll add is the 2 letters, one in support, one against. I guess there were 2. The one against really doesn't address the matter before us, so, yeah. Mr. Maloney seems like an honest guy, so.
Yeah, and the one in support was very specific to this property. Like,
Absolutely.
I live there,
I stay there.
I've stayed there.
Yeah.
No complaints from neighbors, so I'm definitely inclined to offer relief.
Well, it's a 6-month wait. I mean, I think we should consider a 5-month wait just because of the storm. And then operate from there.
I thought you were saying just give a month off, but you're saying like,
I would-
let's
I
call
would
it,
already,
let's,
Even
you
a
would,
totally undeserving person, I
you
would
would
think,
give
just
them a
because of the
month, yeah.
timing of that, it looked like he missed his opportunity to get in here. I might be wrong.
Possibly.
It might not have been possible with the letters that had to go out and all, but
Yeah.
benefit of the doubt. But yeah, what kind of relief are you guys comfortable with?
I'd start with 3 months.
I was looking at 3, also starting the stop work order date.
I agree.
Yep.
And the stop work order date
That's January
was
16th.
January
Which
16th.
would be April 16th, which
Right,
is 3
which
weeks
is,
from now.
yeah, almost,
Okay.
Almost there.
yeah. Do you want to make a motion?
I'll make a motion that we find that the zoning administrator did not err. However, we are willing to provide relief of 3 months, of 3 months starting from January 16th.
Second. Can I see a show of hands? And it's unanimous. Very good. Thanks for coming in, Mr. Maloney. You have a great day. Okay, we have a quick housekeeping matter to deal with, and then we will be on our way. Oh.
Do we need to close the meeting, or are we
Oh, yeah, do we
closed?
need to close the public hearing for this?
I don't know, Robert's Rule of Order.
I think you can keep this in the meeting if you want to.
It doesn't matter to me.
We'll keep it in the meeting.
Okay, I regretfully have to resign my position after this. Today will be my last meeting. It's been a wonderful 5 years, I guess, serving on the board. I've accepted a job with Metro's IT department starting next week, and have been told that there's a potential conflict there, which I understand. This has really been a joy, and as an owner of 2 short-term rentals in my neighborhood, I like to see when the rules are followed, because I follow the rules, and I want to continue doing this. And so I'm really happy to see all of you here, and I hope that you continue with what we've done so far. Thank you.
Mike, thank you. I was very disappointed to hear this news. You've been a great colleague to all of us, and, you know, we've always really relied on your experience, too. I think you were the one of only 2 short-term rental operators that we had on the board, and, you know, we have been dependent on your experience and your take on things. So thank you for everything you've done. Thank you for serving our community and continuing to serve our community working for Metro. So we're sorry to see you go, but this is a great gig for you, and I'm excited. So.
And the staff would like to express their thanks for your service. We've really enjoyed working with you. And we're glad that you're joining the Metro team. And I would like to reiterate with the rest of the board members, quorum is going to be critical
It's gonna
going
be tight.
forward.
Yeah. To that end, and I think I was trying to do it today, sometimes we get very chit-chatty, and I think going forward, we might need to be aggressive about time management, because people have, you know, things like Tom today having to leave. You know, we might miss an opportunity to have full quorum because people have restrictions on their calendars. So we're going to have to be quick and dirty whenever possible. Good?
Are you telling me to be quiet?
No, I promise, no. I'm kidding. No, you'll know.
I don't know,
it.
today
We're not
that might
making
have
a
been-
remark, you will know
That might
it.
have been me today.
Not at all, not at all.
Well, I will say I second that motion.
Okay. All right, well, with that and with all of our thanks to Mike Leutkoff for all of his hard work, we will close today's public hearing. Mike. I know, seriously.
This has been a service of the Metro Nashville Network.